The 6th of August 2025, it's the most beautiful day here in rural Ireland. It is beautiful. A little breeze and a bit of bright sun and a wee bit of cloud, and it is, the temperature is just lovely. I'm here now in the workshop, which is cold because it's surrounded by evergreen trees and that, so it's cold enough, but it's just right here. Anyway, why am I stuck out in the workshop wearing really good clothes? I had a little bit of private business to conduct, and I had it dressed properly for it, reasonably good, and so I'm looking absolutely dapper. Oh, I'm lovely today, lovely. Anyway, but there's a bit of social, domestic, and pleasure going on in the house. A wee bit of coffee drinking and chatting. So I don't want to upset that. So I can do it here in the workshop, which is not all that clean. Now the thing about it is that I want to just impart some of my knowledge to you. I'm not your lawyer. I'm not your solicitor. So I can't accept liability for how my information is used in a court or anything like this, but I want to tell you about the law of contract. It's British English common law. There's a difference. It's English common law. You can't use the word British common law because that includes Scotland, which is slightly different. It's English common law. And one of the sources of Irish law is English common law, and always will be, because it has developed over so long that you can't get it out of the legal system. Now, contract law is unwritten law. Now, there is a Sale of Goods and Supply of Services Act, which is written, and that's more fine-tuning. That says maybe that something must be fit for purpose. How you get it enforced is beyond me. I never managed to get it enforced. I was often sold defective goods and I'd complain. I never heard again of it. So I think it's a bit of a cod. But it's not enforced by the Guard. It's a civil law. So if somebody sells you something, a lawnmower, and it breaks after the first pull, because it's made in some third world country like Germany, out of Chinese parts, well, you can go and say it's not fit for purpose, it's not as described. The best of luck to you. I wouldn't waste my time. It's up to you to watch what you're buying and make sure it's fit for purpose. Anyway, other people may have different views, but the basic laws of contract dates back hundreds of years. And I'm going to give it to you now, because I want you to be nearly as smart as me, but not just fully as smart. You can't have everyone as smart as me, but you could have people nearly as smart. And you get some value then. First of all, there's an invitation to treat. You're walking down the road and you see a lawnmower in the window, and you could do it trading up the lawnmower, €59. And you say, you get your money out and you count it. You get your 59 and you go in, and she's a young one there behind the counter. I want to buy that lawnmower. And she says, I'll check the price. And she checks the price on the computer, and it's €590. Someone left a note out. Would you believe it? I know people who I explain that to, and they can't understand how you could write 59 when it's 590. Some people cannot understand a mistake. Mistakes. Man that never made a mistake, never made anything. Right, there's the money. And she checks, oh, that's 590. No, it's in the window at 59. I have to get it 59. The note in the window is an invitation to treat. It's on a par with an advertisement, really. You know, these things are advertised on YouTube and on BBC and RT and the paper. Dr. Slattery's Egyptian liniment, it'll do this, that and the other, take 2 spoons a day and all of that, and you have no comeback. It's an invitation to treat. Come in and see what you think, and bring that money with you and see how it goes on. Now, in most cases, the price in the window will be right. And if you said, and you'll probably say, will you give it to me at 55? All right, we will. But they're not bound by the price in the window. That's an invitation to treat. Likewise, if I put an ad in the paper selling me tractor for €1,100, and you come to buy it, and it's worth 11,000 or whatever, I don't have to give it to you. Invitation to treat is the basic start off for trade. Now, the next thing is you have an offer. So the person selling or the person buying can make the offer. So we'll say you go into the lawnmower and it's not the right price, that doesn't matter. Now you're still interested. Well, wait till I tell you now, what's the price? $5.90. What will you take? He's offered it to you at $5.90. That's an offer. You say, what's the best you'll take? And he says $5.80. Right, that changes the offer. The offer is now $5.80. You say, I'll give you $5.50. That's a counter offer. That's a counter offer. He receives that offer and he says, oh, gee, I couldn't let go of that. I couldn't let go of that. I couldn't. When I have it here in my pocket, there's the cash there. There it is. Take it or leave it. And you clap it down the counter. That's still an offer. He has to decide whether to take it or not. He might say, no, I'll tell you what I'll do. I'll take $5.70, $5.60 or whatever it is. Right. Supposing we come to $5.60. You usually don't have €5. $5.60. All right, here I have a bit of change here. And you put it out there, a bit of change. Wait a minute, now, zero. There you are. God, you're an awful man. You're charging me that. So now you get €10 more, and it's $5.60. Is that a deal? That's all right. Wrap it up there. Do you want a new one out of the box or what? I'll take that one right there. Yeah, $5.60. The minute he accepts the $5.60, it's now an acceptance. So up until now, you have the invitation to treat and you have the offer. Now you have the acceptance of the offer by the seller. Or the acceptance of the offer could be by the buyer. Whoever says, that's it, I'll accept that. So obviously, if the person selling says he'd take $5.60 and the buyer says, I'll take it at $5.60, I'll pay that for it, then that's the acceptance. The acceptance. Have you that now? Offer, counter offer. All right, it's accepted. And long going to be at this in the fair. Oh, come on. You'll come down. Here's the price. I'll make the price. There'll be an old boy there, and there'll be a neighbour here, Paddy, and there'll be another fella here. Hold out your hand, and they'll be clamping like this. $5.60. No, he said, I won't take $5.60. No, I can't sell the cow at that price. So you know the story yourself. Some of the newer viewers won't have a clue what I'm talking about. But it takes you all night to understand that that's the way deals are done. Then you have an auctioneer doing it. It doesn't matter. Offer, acceptance. Now the acceptance, next, must be communicated. It must be made clear by somebody that that's the accepted price. They're accepting that price. And it must be communicated. And once it's communicated, there's no going back. It's a deal. Okay? It's a deal. Now, the offer and acceptance must include the intention to create legal relations. So this idea of some fella being drunk in the pub and selling his bit of land in the pub, that wouldn't stick. I'd say a deal done in the pub would be illegal. And if there was drink on the job, it wouldn't stick. In any event, if it's land, it has to be by contract. It has to be signed documents. Whereas selling the tractor or the cow doesn't have to be signed documents. Land is writ-based law, so you can't part with it without a signed document, both sides. But otherwise it's the same. So now you have the invitation to trade, settled at $5.60, that's the acceptance. There's the communication of the acceptance. There's not the communication of the offer, it's the communication of the acceptance. When it's communicated between the two parties, both have to have the intention to create legal relations. No codding about it. That everyone will run, oh Val, but what have you having a receipt? Or you have it on paper. The paper only applies to land. If it's done on the street or whatever, it's up to the court to decide on the facts. Usually there's some bit of paper given. But if the deal is made, I take it. That's it, I'll take it. That's the contract signed. And it's up to the court to decide, was it done or not. And now, normally there'd be a witness there to say, that was the deal we made. So offer, acceptance, intention to create legal relations. Now, the acceptance must be communicated by writing if it's an insurance policy. So if your insurance sends you out a policy, you pay the fee, you pay €650 to your insurance policy, and they usually give you some kind of a receipt straight away. You're then they're then on board. You're then insured. Even though the policy mightn't come out for a day or two. They have given you the receipt. That's indication of the acceptance of the offer. And provided you didn't tell any lies, you're insured. Okay? Now you might be better get a receipt nowadays to give it to you straight away, and they give you the certificate. But long ago they'd have to publish it and send it out. House insurance is another example. So it has to be communicated. In the case of the London House Fire Insurance Company, there was a public holiday like the August bank holiday, which is now over, coming up. And the deal was made by post, probably that time, that the insurance on this property would be, we'd say, £80. The insurance company accepted, said, we'll cover you when we receive the money, when you tell us. You're covered whenever we make the deal. And your man posted the cheque on the Friday, and the house went on fire on a Saturday. And when he came in on Tuesday morning after the bank holiday, his shop was burned to the ground or whatever. He put in his claim. The insurance company said they weren't liable because the offer was not communicated. And the insurance company lost because King Henry VIII put the primacy of the postal service first, and he said the deal or the contract happens when the letter is posted, not when it's received. Henry VIII wanted the Royal Mail to be legal. You put the letter in the post, that's it. That's the postal rule on the communication of the acceptance. Otherwise, it's whatever said in the office or whatever. Okay? Invitation to treat, offer, counter offer, acceptance. Communication of the acceptance to the other party so they know it's a deal. It's a deal. Can be a hammer or anything else. Okay? Now, the next thing is there can be no duress. You can't do that with a child of 10 years of age. You can't go into a child whose mother and father has died and get the eldest son to sign over all. That's duress, and that's underage. That's out. Having a person drunk or threatening to stab a person if they don't sign, that's out. Has to be freely entered into. Okay. Now, there has to be a consideration. Some pain must be experienced by the person who's buying. They must pay something. It doesn't have to be money. It might be, I'll give you that horse for that cow. Or I'll give you 3 sheep for that cow. There has to be a consideration. And the consideration must be adequate, but not sufficient. So it must be adequate. So if it's an insurance on your car and it's €59, that wouldn't be adequate. But if it was 380, it would be. So it has to be adequate. It can't be a ridiculous fee. It can't be a ridiculous fee. Now, you might ask the question, what about you buy something there and you say you'll come back tomorrow and you give a €50 deposit? That's an earnest. That helps to prove that there was an intention to create legal relations. You with me on that? It's not the contract. It's you paid an advance or a deposit. That's the intention to create legal relations. But where that is house property or land, that must be transacted by paper, because no paperwork is done when you pay a deposit, they can change that, and that's called gazumping. So you pay €5,000 on your house, they have to give it to you back, but they don't have to honour the deal, because a house and land is the same thing. There's no such thing as a house, there's only land. I'm sorry about a lawnmower going there in the background, nothing I can do. So the house is only the land it's on, and it cannot be transacted otherwise than by paper, by contract signed, and therefore giving a deposit has no effect. It has to be signed. With a tractor or a horse or a cow or a motorbike, it doesn't have to be paper. So therefore giving out an earnest, a €50 deposit, shows that there was the intention to create legal relations. That's all. But it's not essential. An agreement or some bit of a paper will do just as good, or some receipt. You have that. Now, so the offer, the acceptance, the intention to create legal relations, the communication of the offer, which if it's by post is the day you post the letter, That may be subject to some amendment, but that's the general law. Normally, you won't be doing it by post anyway. You go into the office in the local town and you insure your car there and then. But that's the story. Now you have that. I think I've made that clear. Now the consideration has to be adequate. It couldn't be a new lawnmower for €6. In all fairness, I mean nobody'd sell a new lawnmower for €6, so it's not adequate. But if it was €110, that could be adequate. It's a bit of pain. The buyer has to be a bit of pain. But it probably would have to be adequate. However, the courts have a very wide jurisdiction on that. Now, it doesn't have to be sufficient. So if the payment for the lawnmower is 100, it's not sufficient. The lawnmower is worth $590. But there's wheeling and dealing, there's the end of the market, there's the end of the season, there's sales, there's everything. So as long as it's something reasonable, it is sufficient. It doesn't have to be, it has to be adequate. It has to be something reasonable, but it doesn't have to be the proper price. You can't come along and say that lawnmower is worth €830 to buy it in the shop. Okay. Now I had a break there to let a noisy lawnmower go past. It's gone away down again and we get another bit in. So now you have that, the law of contract. Invitation to treat, no legal status. Offer the acceptance of accounts. The acceptance must be communicated. Can be, if it's by post, it's when it's posted. There has to be the intention to create legal relations. There can't be duress or drunkenness or anything like that. Has to be free. If it's land, it has to be in writing, and if it's not land, it can be just by contract. Land is the only thing they insist. They will not allow land to be transacted by word of mouth. It has to be by contract, and that's only right because there's registration and all involved. Whereas with other things like a car or a tractor, that's not the case. We enter into it every day. So now the Sale of Goods and Supply of Services Act fine-tune that a bit, and it has to be as described. But even under old law, if somebody sold you something that wasn't fit for purpose, you could sue, and you have to go to the civil court. It's all civil court law. You have to own the stuff you're selling, obviously, or have the authority to sell it. So now I think that's everything. The reason why this adequate versus sufficient, judges don't want to be deciding what the value of something was. I mean, I show you a lathe here sometimes. I bought it 40 years ago. What's its value? What judge wants to be deciding on that? It's just that I couldn't sell it for €10. I'd have to get 200 or 300 for it, maybe, or something like that. But it's probably worth 1,000, maybe 2,000. A new one, it would be minimal of 3,000. So it's probably worth 700 or 800. But then it mightn't be worth much. Old cars and old machinery might only have scrap value. But that's it. It has to be just adequate, but it doesn't have to be sufficient, because the courts don't want to be deciding the value of anything. But they will know, basically, there has to be some value, some value. It has to be worth something, unless it's junk. And then the question is, why are you selling it? So that's the common law. It's modified by the Sale of Goods and Supply of Services Act, and I'm not your lawyer and don't take accountability for this or how it's used. It works, it's every day. But you go into your hardware store, you get a thing down on it about explaining it, and that's legal. Once there are conditions attached to the contract, they're what applies. So it might be that this will give you a guarantee for 2 months. That's it. If you accept that guarantee, that's just for 2 months. However, if the Sale and Goods and Supply of Services Act says it has to be 6 months, then that overrules the guarantee, unless you sign away your rights. So if they said, right, you have certain rights when you buy this mower, but we don't want to see it again, right? The price of that mower new is $1,100. Just saying. We'll give it to you for $590, but you must take it away and sign away all your rights. You can renounce all your rights. No comeback. And they often get things sold as seen. No comeback. And if that's part of the contract, that's that. Now you might ask about an auction, selling cattle or selling cars. Well, the offers are made to your man. He's acting as the agent for the seller, so to the auctioneer, and he comes along and he sometimes they put it on the market. It really has very little effect when the sale takes place. If you bid and it's on the man, going to sell it, sold to that man over there. Well, if it's land, it has to be put through the contract system. But also, it's not the same as an offer between the people. There's an agent involved, and there could be issues about it. But once the allotted time, you might have an hour to check your animal. Once that allotted time is over, then you are contractually binded. The possession leaves one person to the other. Right, we'll do it that. I hope that's some good. 20 minutes. I hope that helps you a bit. The lawnmower's coming back. Bye bye, bye bye, bye bye.